My name is Parna Mehrbani. I'm a partner here at Tonkin. I'm the co-chair of our firm's intellectual property practice group, as well as our IT and data security practice group. This is our webinar on the California Privacy Rights Act of 2020. Joining me is my colleague, Alexandria Wagner-Jakubiak.
So there's a couple states kind of quickly following suit in implementing privacy laws. Some look more like California than others. I will say that California is definitely the most protective of consumers' privacy rights. So some of these will be a little less burdensome to comply with. First, we have Virginia. Virginia went into effect the same time as California's. However, it does not have that look back period like we do have in California. We're also going to look at Colorado, Connecticut, and Utah. And this is a great visual to look at later to get an idea of where its privacy laws stand in the process of being enacted, or if they're even being talked about. So Virginia is already in effect. A couple of main differences. Remember that covered organizations test. If you're a for-profit business that collects, sells, or shares California residents' data, and you meet one of the three thresholds that we talked about. Remember that first threshold was gross revenue in the preceding year. There's no gross revenue threshold. So you either have to be making half of your money from selling personal information, or you're holding on to, for the duration for a year, personal information of at least 100,000 Virginia residents. There's also an expanded opt-out right, kind of calling it the opt-out plus, where not only can consumers opt out of behavioral advertising, but also profiling of any kind and targeted ads of any kind. So really the whole gambit. And then lastly, there's more blanket exemptions, especially for financial institutions. And they treat consumers that are part of loyalty programs with a business different than consumers that are not part of a loyalty program. So that might be something to think about if a business offers some sort of loyalty program to its customers. Then we look at Colorado, which is coming into effect July 1st. That's when, that same time that enforcement for California is going to start. And there is similarly no covered entity threshold when it comes to the gross amount of money that you make. So just like Virginia, no issue there if you only would have been covered because of the amount of money made in a year. There is a new consent to have sensitive data, which is defined just a little bit differently than California's. You have to get this consent before you process it in any capacity. So it's a little bit more than an at collection notice. It's at collection before process. And then lastly, the major difference is in, let's see, it's 2024, I believe. They're going to require in Colorado a universal opt-out requirement. It's basically going to mean that the state will come out with technical specifications that you have to meet, that every business will have to meet that's covered by the regulations. And it's a one-size-fit-all type of way that consumers can interact with your website or your app to opt out, especially when it comes to like sensitive personal data. All right, that brings us to Connecticut.
All right, so looking at the Connecticut law, this one is also effective July 1st of 2023. Again, there's no covered entity threshold based on revenue. This law also has a requirement of consent to processing sensitive data before the processing happens. And the sensitive data here includes any children's information. Reasonably, employee and business-to-business data are exempted in Connecticut. Connecticut has a right to appeal, which you saw on some of the other slides. That just means if a consumer requests, for example, that you delete information and you decline that request for one of the reasons that are permitted, the consumer is allowed to appeal that decision. Connecticut does not have a right to notice at or before collection. So that might give you the opportunity to have a shorter privacy policy, but in most cases, you're probably going to have that right to notice in your privacy policy anyway, because of the requirements of the other states. There's also a right to opt out of profiling and targeted advertisements, and you do get a 60-day period to cure if there's an enforcement issue in Connecticut. Utah is the next one on our list. This one is, I would say, the most different from California. Like this one is effective December 31st of 2023. Like the others we've talked about, there's no covered entity threshold based on revenue alone. It's revenue plus the processing of 100,000 consumers' data. So it's sort of a dual requirement. So again, making it a little bit more, making, I would say, fewer businesses covered. So it's more difficult to be covered under the law, or you need to do more, there's more requirements to be covered under the law. Utah also has a narrower definition of personal data and the sale of personal data. So personal data is defined as the first name or first initial and the last name combined with either a social security number, a financial account number and password, or a driver's license or state ID number. So again, it's a combination of multiple things that that fall under the definition of personal information. There's also at collection notice required an opportunity. You have to give an opportunity to opt out of, again, the processing of sensitive data. And then you see a few other differences there. There's no duty to avoid secondary use by whoever controls the data, and the consumers do not have a right to correct their data. So we wanted to briefly talk about what's going on in Oregon. Oregon's Attorney General, there is Senate Bill 619, and it is the product of an incredible effort by the Oregon Attorney General over the past several years to essentially bring together a task force. There were over 100 participants in an attempt to have an Attorney General-led consensus piece of legislation. The first public hearing in the Senate Judiciary Committee was just March 7th, and it's scheduled for a work session on March 28th. Whether or not this law is going to pass, we don't know. From the business perspective, there is a significant opposition because there is a private right of action in the current draft, which would allow individuals to bring claims. And there are also some directors and officers liability provisions, which again, businesses have been very adamantly opposed to. There has also been some opposition to health data and financial data are currently not exempted, I believe. And so there's a lot of work that needs to go into this, but it has been ongoing work with the Attorney General and the work group for several years. So it is an active discussion in Oregon. Also to keep in mind, some other states that have privacy legislation on the way is Indiana. That law is modeled after Virginia. Maryland considered biometric privacy regulation that passed in their House but got stalled in their Senate. Michigan, and then, as I mentioned earlier, Oregon also has a similar children's privacy law that they're considering that's similar to the new law in California. At the federal level, I think it's worth mentioning because there we have this hodgepodge of state laws, which is always more challenging because the rules are different everywhere. So at the federal level, late last year, the federal government waded into the privacy space with the American Data Privacy and Protection Act, ADPPA, which was introduced in the House on June 21st of 22. It did receive some bipartisan support. This would be the first comprehensive national privacy law, and is being advertised as a major step in putting people back in control of their personal information. I think there was just some encouragement by the president in the last State of the Union that this should be a top priority. But we'll see what happens with it and if the federal government can make any sort of progress. So how to prepare for enforcement. Obviously, this is going to really depend business to business, but the very first thing to do is to identify what data do you collect. And this really requires looking at all of the parts of your business. So from your IT to your marketing to finance, what is auto collected, what do you have from people, and why do you have it? Do you need it? So I always give our colleagues in marketing a bit of a hard time because they tend to like to collect as much information as possible, just in case we might need it later, might come in handy later. And those types of collection processes may now be subject to more scrutiny because there's a lot more requirements on what you do with that data if you're holding it. Obviously, you want to look at those threshold requirements in California and determine if you fall under the law. And a question will be whether you want to treat all of the data that you have the same, whether you want to give all consumers the same rights for ease of internal process, or if you want to carve out California to limit the amount of work and carve out the other states that have laws that require responding to consumer requests. So those are some decisions on the front end. So identifying high-risk data processing activities, conducting regular risk assessments and determining if any sort of annual cybersecurity audit is needed. As I just alluded to, developing an internal process to handle consumer requests. Updating, this is a very important one because this is the most public-facing piece of this, is updating your at-collection privacy notices. Most people refer to those as their privacy policy. It's largely available on folks' websites. So updating that, and then determining if you need a California-specific privacy notice, potentially a California employee-specific privacy notice, evaluating and likely modifying any contractual arrangements or that you have with any third parties that govern the transfer of data or involve the sharing of data. So these are all concrete steps that you can take. And obviously, these are going to vary. The specifics of all of these action items are going to vary business to business, depending on what you have and why you need it, what you do with it, who you share it with. And I would just reiterate that although some of these laws are not yet in effect, certainly the California law, the CCPA is currently in effect, and the CPRA just came into effect. And even though enforcement does not start until later for the CPRA, it does look back at data that you're already holding. So we're going to stop there. And I do just want to reiterate that when there are going to be regulations coming out in California, And our goal is to continue to update you on this information and give you updates on those regulations as well.